everyone. Welcome. Excited to have you here today. Today we are discussing multi-jurisdictional employers. This is part 2 of a 3-part series where we discuss common state-by-state considerations if you happen to be employing employees in a number of different states and jurisdictions. Here today, we're going to be talking specifically about non-competes and non-solicitation agreements. These cause quite a bit of grief in our labor and employment practice. So we're going to give you a high-level sort of introduction, rules of the road, important considerations. One very important sort of PSA before we dive in is that these things are changing very quickly. And so even as we speak today, Zach and I were laughing over the fact that July 1st marks a lot of changes. We've got changes in Maryland, changes in Virginia. I'm sure there are other states that are also joining where there are constant updates. So we're going to get into some of those. Apologies, we meant to be on camera, but the technology conspired against us. So we are talking to you from the void, but very excited to have you here. Welcome your questions. And again, because it's so state specific, if there are particular nuances of the law, it might be we could talk about it offline or via email, but there's a lot of nooks and crannies here. Honestly, if we were to give you a full deep dive into the non-compete world, it would probably take several days. So we're going to talk high level, just give you just enough to understand where you should ask questions, what you should be looking at and considering, and hopefully that'll prepare you well as you sort of navigate your future in these different areas. So without further ado, Kaylee Flagg, thank you, is going to be helping us with the slides today. If we could get started, Kaylee, that would be great, and just dive in. Oh, I should probably do introductions, huh? So I'm Sarah Nash. I am a partner in our labor and employment group at PilieroMazza. We are often dealing with employment law considerations, agreements, handbooks, policies. Non-competes, non-solicitation provisions take up quite a bit of our time, whether it's drafting the agreements themselves or figuring out how enforceable a prior agreement was. We've got clients on all sides trying to figure out who they can hire, who can't hire, what employees are actually restricted from engaging in. And so this is, I think the reason that we decided to add this to the list is because it comes up often. There's a lot of confusion. And also there are a lot of easy tips that can set folks on the right direction. And I will let Zach introduce himself. Zach, could you tell us a little bit about you? And Kaylee, could you go? Great.
Sure. No, I'm Zach Stinson. I'm an associate in the Labor and Employment Group, and I also work at the litigation group. And I have a fair amount of experience with trade secret, non-compete, and restrictive covenant disputes, counseling, as well as drafting of these agreements. And I'm happy to share the information from high level today, from observations over years of experience in counseling employers, as well as representing them in court.
Great, thanks, Zach. Kelly, could you show us sort of an overview on the next slide? I think we do. PilieroMazza. You guys hopefully know us by now. We're a full service law firm. We've got groups such as my personal favorite, labor and employment, but we also have litigation teams, government contracts, construction, business and transactions, and a few other focuses. And we really serve folks. So that's us. And without further ado, let's dive into the slides. We got a question asking if there are slides or course materials available. Hopefully you all can see the slides that are on the screen. If not, I'm pretty sure make those available shortly thereafter. Fair warning though, we do not get into a lot of the details just because there are 50 states and it would be a lot of boring case law and statutes. But I can tell you, if you do need specific information about specific states or you'd like some citations, I know we have them available. We have some resources we put together as a firm over the years. Happy to help you out and send over what might be helpful. So let's talk a little bit about the focus of today's webinar. For the next hour, or so, Zach and I are going to be talking to you about non-competes and non-solicitations. I'm going to give you a brief overview of what those are, and I think more importantly, a brief discussion of, important considerations to make sure they're enforceable, make sure that you as a company stay out of hot water when it comes to certain enforcement mechanisms, and generally just focus on best practices to protect your IP or to protect your confidential information as a company. Other things we're going to discuss, we're going to talk about some guidance on avoiding common pitfalls in agreements. Again, pretty much every state is different when it comes to these things. So there are some surprising similarities, but also differences as you're navigating. I think something that we're going to echo sort of repeatedly throughout this conversation is how important it is to make sure to date on your particular state laws, because as I mentioned, Virginia's new law on non-competes just went into effect today. Maryland had a new higher restriction on healthcare professionals that went into effect. And so there are quite a bit of changes that are happening, almost on a week by week basis. We're also going to get into some of the specifics as we work through different states. Some states, as you can imagine, are sort of a heavier lift. We've got some states that are a huge no-no for non-competes. California is one of them. And we'll go over some of the sort of ways that you can best draft your agreements to make sure you're complying with specific state laws. And without further ado, we're going to jump into the first substantive slide. I still don't see. Let's just start diving in. Thanks, Zach. Zach's gonna be our tech guru for the day. Thanks, Zach. Zach and I, we were so excited. We're coming to you from the same room at PilieroMazza's DC office, and again, couldn't figure out the tech to be on camera, but we're here. So let's talk a little bit about restrictive covenants generally. There's a general idea that you are talking about non-competes, non-solicitations, and non-disclosure agreements when it comes to how you can sort of control your employees post-employment. These are tools that you have in your tool belt as a company to protect the company IP, to protect confidential and proprietary information. You're also given the ability to protect some of the goodwill that you invest in employees. We all know it takes a lot of time and resources to bring employees up to speed to the point where they are fully contributing. And so it's so important, right? Regularly, we have clients asking us, how do I make sure that I'm not just throwing away these resources that I've invested? But we're going to talk a little bit about how you can use these restrictive covenants, whether it's a non-compete, a non-solicitation provision, or a non-disclosure, to really make sure that you guys are providing sort of a good working environment where your IP is protected, and you are not throwing, money after losing employees. And there are some carrots, there are some sticks. We'll talk about those options. Thanks, Zach. That was beautiful.
We'll see if it works.
We'll see if it works. So, Zach, restrictive, I think let's just do this. There we go. We've moved on. So restrictive covenants and general non-competes, non-solicits. When you are talking to clients about these types of issues, what are some high-level issues that you want to know first off in order to, really best counsel a client?
Well, I generally want to know what interests the employer is trying to protect. Is this person that they want a non-compete or other restrictive covenant for? Are they in business development? Are they in developing technologies and have the company secrets at their disposal? Or are they dealing with a lot of confidential and sensitive information? Aside from technology or employee personal identifiable information, or any other sensitive matters dealing with the company. And that kind of is going to guide us on what are the best legal avenues to put in the agreement. Do we go with a non-compete, a non-solicit, or an NDA? Do we want to protect the relationship with one of the company's largest clients, that the employee has been interfacing with for years? If that employee were to leave and tries to steal that client, how can we protect against that? And so those are a lot of the considerations that we're looking at, in assessing these agreements, whether we're drafting them or looking to see if they're enforceable, or looking at things from the other end.
That's great. And Zach brings up a really good point, which is these are not one size fits all. Sorry, Zach said that earlier, and now I've got it stuck in my head. They're not one size fits all, which means that really every employee is going to be different. And it's not just the state that they're in. It's are they a current employee or are they a new employee? It's what's their role with the company? What access do they have to your trade secrets, to your confidential information? And so all of that, often we'll have clients say, hey, I just want one agreement, send it over. That's fine, because, honestly, it can work. But is it the best approach? Probably not. Probably best approach is you tailor each agreement. And I know some folks out there are probably rolling their eyes like, really? You want me to tailor agreements for all 500 of my employees? No, thank you. But this is all a series of risks, right? And so ideally, you've looked at the specific state where this employee is. We live in a world where employees move frequently, right? So it's not just where they are when they sign this thing. It's where they are in the future. We probably are going to need to reevaluate if they decide to move, if you let them move, what state laws are going to apply. So it can be a very fact-intensive consideration. I do want to emphasize that we're talking about restrictive covenants, non-competes, non-solicitation, specifically in the context of an employee to company arrangement. We're not talking about the sale of a business. We're going to talk a little bit about company-to-company agreements, but really in the shadow of restrictive covenants more generally for employees. And the only reason I mention that is because there are different rules that apply. When you're looking at an employee in their individual capacity, negotiating or being subject to an agreement with their employer, very different considerations at play from sale of a business where you might have an owner who is now subject to a 5-year non-compete in pretty much the entire universe of whatever it is, the industry that the work is in. That is not going to fly in the employee relationship. And so I just want to put that out there. There are differences. Companies present this very differently. Another consideration is, and I still receive questions about this, Zach. I don't know if you've also been getting questions, but this FTC rule, didn't the FTC just ban these things? Why are we even talking about non-competes? What's going on there?
Yeah, the FTC under the Biden administration did come out with a very broad ban on all non-competes that would have applied in every single state in the country. However, even before the rule would have become effective, there were lawsuits and several courts enjoined the FTC from enacting that rule. And where we stand now is those injunctions are still in place, and we do not anticipate that the FTC under the new administration is going to go forward with the rule. It most likely will be taking steps to rescind the rule, but that's not an automatic process, and we'll have to jump through some bureaucratic hoops to do so. So really, for all intents and purposes, the FTC rule that is banning non-competes is a non-issue at this point.
Yep, agreed, 100%. Unfortunately, some companies are rejoicing, right? There's no ban. Great, we can limit employees in terms of their future employment. Other companies are sort of groaning and saying, really, this means I have to learn. I mean, maybe it's just me, maybe I'm projecting, but yeah, that means that for the time being, state laws can control. And this is part of the reason that we're putting together this multi-jurisdictional series, is because a lot of companies have kind of questions about, what state law applies. Is it the state where the company is? Is it the state where the employee is? Is it the state where the client or the customer is? And ultimately, when it comes to these kinds of questions, it's generally the state of employment. So the state where the employee is performing the work. I say that with a little bit of caveat because, I mean, that's the case for state sick leave. That's the case for, I know, independent contractor considerations were on the docket last time. But for the most part, that's how it is with the restrictive covenants as well. There are some caveats, though. Some states tend to consider the state law of the agreement to the extent that it's not offensive to, the public policy of the state where the work is actually being performed. Different courts have different opinions, but safest approach is to put probably the state of employment. This avoids running into problems like, for example, California. We'll talk a little bit about how California absolutely despises these things. You cannot have a non-compete with your employee in California. Very, very narrow circumstances can you have a non-solicitation provision, and it's really got to be tied to your trade secrets. And California is one of those states that says, I do not care if you list your choice of law as Maryland, which has, decent approaches to these things, still not going to control. No, not only that, if you try to pull a stunt like that, there are severe penalties that will apply to you. And so it can be a little bit tricky. That's why we encourage you to really evaluate these things on a case-by-case basis. There's about 13 states out there that have pretty severe penalties, monetary penalties, for a violation of their restrictions on non-competes or non-solicits in some instances. So it's good to just understand the world that you're living in. As we've discussed, different states have different laws. Some states apply these through common law. So there's a various assortment of cases that have evaluated non-competes, talk about the different nuances. Other states have actually legislated statutes, talked about how Maryland and Virginia are still legislating. It seems like every few years they come up with new ideas for either the threshold, monetary amounts that they apply, or the type of employees. Virginia just added basically a ban effective today that prohibits non-competes for non-exempt employees. Those are those hourly employees. You can't have a non-compete in Virginia anymore for those employees. So they are constantly changing at a quick pace. Choice of law and venue provisions are going to be pretty important as you're evaluating these. Again, different states have different approaches, so that's also a part of the consideration when you're drafting an agreement. A really big consideration is that some states do not take kindly to overly broad agreements. Zach, you want to educate these fine, wonderful people on blue penciling and how that factors in?
Sure. Blue penciling, can actually be helpful to an employer that's trying to enforce one of these agreements. But yeah, to the extent you're in certain states like, New Jersey, Maryland has some limited blue penciling, and then there are some other jurisdictions, where the judges will blue pencil. And blue penciling essentially means, okay, employer, the agreement on its face is overbroad, but we, understand what you're trying to do here, in not letting your former employee go to work for a competitor. And so, what the judge will sometimes do is strike out certain portions of the agreement that would be overbroad, or offensive to fair competition in that state. And sometimes they'll go ahead and rewrite the agreement. and essentially say that, you know, we're going to go ahead and fix your mistakes and, you know, let you enforce this agreement against this employee who has gone to work for your competitor, even though the other, you know, otherwise the agreement would be unenforceable.
Exactly. And the reason this is really important, right, is because if you are in a state or a jurisdiction that blue pencils, it is easy to draft a non-compete, because all you need to do is include a really broad provision and a judge will fix it for you.
Mm-hmm.
It doesn't necessarily mean it will apply to the circumstance you're trying to apply it to. Those facts are still relevant. But generally, you can just have something really broad, no harm, no foul, we'll fix it, don't worry about it. In states that do not blue pencil, like Virginia, for example, your overly broad agreement, let's say you say no one can work anywhere in the world. In Virginia, that's the sort of provision that's going to be struck as overly broad, period. You can't enforce your non-compete. So there are some pretty big consequences depending on if you're in a state that blue pencils or a state that doesn't. And it's important to, that's one of the first things that we look at as attorneys when we're trying to evaluate the enforceability of these things. Is it overly broad, and does it actually matter depending on the jurisdiction that applies? The last thing that's sort of a big overarching consideration is consideration. It's sort of a legal term. It's this idea that when you have an agreement, there needs to be a tit for tat. There needs to be some type of benefit that each party is getting to make the agreement enforceable. And some states, such as West Virginia, for example, have come to the determination that your ongoing employment is not sufficient consideration for an employee. What does that mean? It means if you are going to try to bind an employee, a current employee, to a new non-compete or a new non-solicitation provision, you generally need something more than, you know, I'm going to continue to employ you for some undetermined period of time. Generally, that could be a bonus or a promotion. It doesn't have to be a lot. Usually it's something in the ballpark, I don't know, $500 or something. But you need to give some additional plus to the employee, because it's not enough to just say, well, good on you, you continue to be an employee. Some states are going to say that's perfectly fine, right? Some states, it does not matter, but it's really important that you identify which state, because let's say you listen to this wonderful webinar today and you say, that's it, you know, we need to take another look at our non-compete provisions, our non-solicits. Let's brush them up. Let's make some changes. That's all good and well, but you need to be thinking about this consideration piece for your current employees. Not a problem if you're offering new employment to people, but for current folks.
I would add a caveat to that. In most jurisdictions, there are some jurisdictions that require something extra, even when an employee is starting employment. If you're going to have them enter into a non-compete agreement that you want to enforce down the line. I think Massachusetts might be one of those.
Yeah, Massachusetts. You know, Massachusetts is one of those ones. I'm going to let Zach talk about garden leave on one of these future slides. But yeah, they've got some really creative, you know, I feel like someone in Massachusetts legislature must have been really wronged by a non-compete in a former life, because they really went to town on some new ideas for how to limit those things. That is a very good point. And we'll talk a little bit about how it's not just enough to have new employment. Sometimes you have notice obligations. Sometimes you have to provide additional written expectations. And so, yeah, there are some creative ways. Not all states are created equal in this regard. Okay, let's jump in. Okay, so we're going to talk a little bit about non-competes. They are different from non-solicitations. I'll talk about the difference, although it is the sort of thing that sometimes can make your head spin. If you're someone who hates the finer data points, maybe put on earmuffs for this portion, because there are some nuances that can be frustrating. But we'll talk about non-competes, we'll talk about non-solicitation provisions, and make sure that you guys can understand why they can be useful, the differences, the different considerations, and what you need for your particular, purposes. Generally, under a non-compete agreement, you need to evaluate what the period of time that the restriction is going to control after employment. Rule of thumb in most states, I think, is somewhere in the neighborhood of 1 year to 2 years. I say that with the caveat, some it's 18 months. It really depends on what's reasonable. And it's also going to depend on the role. I wish I could say, yes, in Virginia, no matter what, you got 2 years, you're good. There are some considerations when it comes to the type of role that someone's performing. There's no bright line rule, but generally you got to think about your restricted period, how long the employee after employment is going to be bound by these limitations. I will say that this is after employment. You can certainly limit your employee from engaging in certain types of behavior during employment. There are some limitations on that. For example, DC has an anti-moonlighting provision, which says you cannot have a blanket prohibition against all moonlighting. Moonlighting is, where someone has a second job on the side. California, no surprise, another example where they limit moonlighting. But generally, you can limit your employees' employment while they're employed. So we're really talking about that post-termination period. Another piece of this is sort of the type of restriction that you're going to impose. Zach, do you want to talk a little bit about kind of customer base versus geography and how that all ties together?
Sure. So, Sarah, aside from the period of time that you would be restricting, and what the court is going to evaluate to see if it's reasonable or not, you also need to look at, are you going to restrict someone to this agreement just within a certain geographic area? Let's say you just have auto shops within a 3 or 4 county jurisdiction, and one of your employees leaves. They're the most valuable employee, and they're going to go open up their own auto shop and take a bunch of your clients who want to go have their cars repaired with them. Well, in that type of situation, you would want to consider limiting his competition to really where your customer base is located. Because a court might find that, okay, if he's going over to another state, or if he's going to the southern part of the state to open up his shop, he's not drawing on your customer base, and the agreement's otherwise unenforceable because it's just overly broad from a geographic standpoint. So if you do have a geographic-based business or clientele, then you want to look at narrowly tailoring those geographic restrictions to what is actually going to protect the business, protect the goodwill, or protect your interests. And then from the flip side, if you have customers or clients that are located anywhere in the country, like most businesses do these days, then you want to look at implementing a customer-based restriction. And then when it comes to that, you also want to narrowly tailor it. If we're talking about selling auto parts online, for example, you don't want to say, this person cannot go work in the retail industry anywhere in the country for 2 years or so. That would be unreasonable because there are lots of retail businesses that would not be competing with the auto parts business. You would want to narrowly tailor that agreement, just to your industry, and even sometimes name specific competitors. That can way to make these agreements specific and enforceable. If you have 3 or 4 main competitors, go ahead and you're fearful someone jumping ship and going to them, taking your goodwill, taking your confidential information, and we're taking anything else, then you want to go ahead and list them in the agreement, and that can sometimes be more effective than just trying to broadly define who your competitor might be.
Absolutely. Um, we represent a lot of government contractors, and I'd say almost exclusively it's the customer-based restrictions that are going to be most useful, because obviously your government customer, they're based in DC. That doesn't mean that all your employees are there. It doesn't really do you a lot if you've got an employee based in New Mexico, right? And you say they can't work for competitors within 50 miles of their work location because your customers in DC, or your customers all over the country, depending on things. So the customer approach is sometimes a little bit more useful, whereas, you think of dentist offices, doctor's offices, automobile mechanics, like Zach mentions, geography might play a bigger role. The other consideration is, and this is where some of the confusion between non-competition versus non-solicitation is. The idea of a non-solicitation provision is you're limiting that employee from soliciting, either directly or indirectly, work from your customers. When you're thinking about non-competition, it's less about what specifically they're trying to solicit the work from. And it's more about where they're working, right? So if you have a customer-based restriction, your agreement is going to say you can't work for a competitor who's providing the same or similar services to our customer X. And I do want to be clear, you can't say the US government, for example. That's not going to fly. That is way too broad. That's a good example about how that's not narrowly tailored to your particular interests. And frankly, you can't even say something as broad as the Navy. You should be focusing on the specific offices. And often it's easy enough. You don't necessarily need to put a list of your customers. You do have to have a sufficient definition that really narrows in the type of work that is being limited. Another consideration, and this is an important one, is going to be you can't prevent someone from performing completely different services from what they've been performing for your company. This is often referred to as the janitor rule. Zach, you want to walk folks through the janitor rule? I think it's kind of fun.
Yeah, I mean, it's got a great name.
Yeah.
Easy to remember. So if, let's say you've got a top salesperson working for you, and you put in their non-compete agreement, you are prohibited, from holding stock in a competitor for a period of 2 years after you leave your employment. You are, prohibited from working in any capacity for that competitor. You can't work as a plumber for them. You can't work as a janitor. You can't, work in their IT department. A court is going to look at that and say, well, what competitive interest are you trying to protect with this agreement? You're not protecting, any goodwill if you've got a salesperson who goes to a competitor and is not interfacing with anyone outside of that competitor's business. And a court is going to say the agreement's overbroad and not enforce it. So that is something you want to be considering. You want to limit in a non-compete agreement the type of role that is similar to the one the employee is performing now. And restrict, narrowly tailor it to any sort of similar role that they would be doing for your competitor.
Perfect. Yep. And I will just mention that I have reviewed, I don't know, hundreds of these non-compete agreements over the years. And often, all it takes is, if you're in a state that does not blue pencil, all it takes is one error that's overly broad. All it takes is one reference to, anywhere in the world, or any type of services that the employee could possibly provide for a competitor. And all of a sudden, your perfectly drafted non-compete provision is out, which means that it is void and unenforceable, and in some states could be seen as a violation of their statutes against unenforceable non-compete. So it's really important you are taking a close look at the language. Sometimes it is like a little bit of a brain puzzle. You have to read through, make sure that you understand exactly what's narrowing what to ensure that it is a well-drafted agreement. And this will also be our little soapbox plug. That, non-compete agreements are kind of on the outs. I think that the FTC's rule scared a lot of companies away from them. For that purpose, they're focusing on the non-solicitation provisions a little bit more heavily. And just generally, they're just not as favored as they once were. Is that right?
No,
Zach?
I think that's absolutely right. And especially when you have a mobile workforce that could, where your employees could move to California or Massachusetts or Colorado or anywhere in the country, and then get that non-compete voided by a court. It's going to be a safer bet to rely more heavily on the non-solicit and non-disclosure provisions of an agreement. For instance, I mean, let's say a competitor, wants to poach a whole section or a whole division from you. Well, they're looking at these employees' agreements. They see, that they're under Virginia law and they're based in Virginia, but this is a highly valuable division, and the competitor goes ahead and moves everyone out over the weekend to California, and this has happened before, and starts employing them right away. Says that your non-compete is not going to be enforceable in California by California courts, and it won't be.
Yeah. And just everyone out there, if you're listening, you should always have, in my opinion, a non-disclosure agreement in place. Non-disclosure, work for hire provisions, depending on the state, duty of loyalty. There are other, tricks of the trade that you can use to protect your information. There are some, we'll talk about them in a little bit, some of those carrots you can offer to your workforce to encourage them to stick around. There are different approaches and different tools at your disposal. We also see from time to time folks who don't necessarily have the agreement on the front end, they put it on the back end in a separation agreement. So there's a lot of ways to address these issues if that has not been clear so far. And again, we're going to get into a few more examples, but just there's ways to be creative. Often in the law, it's black and white. This is the rule. This isn't. This is not one of those places. There's a lot of gray area, which is why one of the few places where lawyers can actually be helpful.
No, I think that's right. And sometimes there are judgment calls to make based on your risk tolerance and where this employee might go later on.
Yeah, for sure. Okay, so that's non-competes. I think that's it for there. We're going to talk about the quirky state rules in a little bit, but unless anybody has questions about non-competes, we're going to drop on to non-solicitations now, the sister to non-compete agreements. Like a non-compete provision, you need a restricted period. Generally, I think rule of thumb is 1 to 2 years. And this is a provision that limits an employee who's leaving from either taking other employees with them or taking clients with them when they go. There are some industries where that sort of restriction is a no-no. For example, in the practice of law, there is this general idea that a client should have the ability to go with their service provider that they choose. And so there are some limitations depending on the industry. But generally, non-solicitation provisions are an accepted part of different industries. Like with a non-compete, it's really important that these are narrowly tailored. It is very easy to, depending on the state, unfortunately, I wish I could say there's a very clear federal law that makes all of this very straightforward. It doesn't. It's state by state again. But a little bit less. They are not as hated as non-competes by a lot of states, so there aren't as many restrictions. Some states put salary basis thresholds, so if you earn under a certain amount of money, you can't be bound to a non-compete. There are a few states that add non-solicitation agreements or provisions into those types of thresholds, but the threshold is often much lower. So they kind of appreciate this idea that non-solicitation provisions aren't restricting an employee's movement so much as limiting the sort of business avenues that they can go after. And so when you are drafting these things, some considerations, courts and I've worked on some recently in Maryland or Virginia, and so this is fresh in my mind, but it's important that it's specific to the clients or the employees that this particular employee interacted with. In other words, if you got one employee, one very specific division within your company, that does not give you the flexibility to ban that employee from going after every client you ever had. The specific restriction should really be limited to the clients that this individual interacted with or had business with or knew confidential information about, and within a very specific period, generally, I think, 2 or 3 years maybe prior to their separation from the company. If you don't have those sort of guardrails baked into your agreement, you could end up, if you're in a state that does not blue pencil, having nothing. And so it's really important that you take a close look. And again, it can be somewhat of a brain teaser as you're reading through these things. Make sure that every single box is checked so that it's narrowly tailored to the company's actual protectable interest. A quick aside, just because we work with a lot of government contractors, there are often circumstances where a contractor will lose a contract, due to no fault of an employee's, no unfair competition, and they will want to keep a former employee from performing work for their former client. That is always going to be a touchy circumstance, because in that situation where you, let's say, unfortunately, you are the contractor that has lost their contract, you no longer have a protectable interest in performing that work. You lost the award. This is, again, assuming that there wasn't any bad actor, maybe selling your trade secrets or violating some other duty of loyalty to you. But assuming it was fair and square, you lost, you can't then keep that employee from performing work for that customer, because your protectable interest is really contingent on you having the ability to have that business line. And if you've lost that, then you have lost the ability to keep that employee from performing the work. It works both ways. Sometimes we've got clients saying, I really don't want to keep my employees from performing the follow-on work. If I lose it fair and square, no big deal. Can you make sure the agreement doesn't say that? Other times you've got folks who say, yeah, I don't want them out there. They're going to make it difficult, but there are some restrictions on how far that sort of can be extended. Another tool that we've put here, even though it's a little bit outside the scope of employee to company, is this idea of a company-to-company no-hire or non-solicitation arrangement. Zach, you want to walk folks through kind of how that can be used as a tool and how it's different from employee to company?
Yeah, sure. This is usually used in a situation where you have two companies, they join together in a joint venture to provide services or otherwise engage in business. But they don't want to risk losing their employees to their business partner, either during the joint venture or for a period of time after it ends. So they'll enter into a no hire, non-solicit arrangement as part of their joint venture agreement, and that would typically prohibit them from poaching any of the other businesses or the partners' employees, both during the pendency of the joint venture or for a limited period of time afterwards. However, you want to be careful about these types of agreements as well, because while they can be enforceable, on a narrow basis, you start to run into trouble if you are either prohibiting, or agreeing with another company not to hire any of their employees whatsoever for any period of time. And that can raise federal antitrust concerns as non-competitive activity, and you might risk, a criminal investigation by the Department of Justice. Whether that might ultimately result in criminal liability, is questionable, but that is not something that you want to deal with in the first place. And then the risk usually at the state level is if it is overbroad with respect to the employees that are covered under this agreement between the two employers, or there is no limit on the number of years after this business project ends, a court is going to find that to be anti-competitive and not enforce it under public policy grounds.
Yeah. And this wouldn't be a multi-jurisdictional webinar if we didn't also mention that these company-to-company agreements are also evaluated on a case-by-case basis. There was a case that came out at this point probably 2 or 3 years ago in Pennsylvania that really hit hard on company-to-company non-solicitation arrangements and really emphasized the importance that it's narrowly tailored, and really drew some strong comparisons between limiting employees' employment through a non-compete agreement or a non-solicitation provision and having that same impact on company or on employees with a company-to-company agreement. So again, really important to understand the nuances of what state law applies and how courts are evaluating it. Okay, so that's non-solicitation provisions. That is not where your options sort of end, right? There are some other, variously useful tools that you can have in your toolbox as you're trying to protect these sorts of interests. The nice thing about a non-compete agreement, right, is if someone's working for a competitor. You don't necessarily know exactly what they're doing, but it's a pretty good, we've got LinkedIn, you've got other resources, maybe they're listed as a key personnel on a solicitation or a proposal. But there are pretty clear blueprints to show you, or the breadcrumbs to show you what exactly that employee has done in violation of their agreement. Non-solicitation provisions are also sort of useful in that it's easier to draw a direct line between the employee's behavior and their solicitation or participation in a bid or some type of proposal that's then submitted to your customer. You can also kind of follow the breadcrumbs. NDAs, while they're very useful, don't always show you those breadcrumbs, right? It's not as easy to show that a company or another company or that your employee is relying on your confidential information. And so it's one of those things, really important to have it. It's just that it's not always the easiest thing in the world to show that it's violated. That said, I 1,000,000 times over 10 would prefer a case that relies on a violation of an NDA over a violation of trade secret protections or violations. Because you want that agreement in place. And there are ways that you can show violations without one, or without a non-solicitation provision, or without a non-compete provision, just varying degrees of what it takes to show like the evidence in court if you do want to go after someone for stealing your work. And so NDAs, yes, great resource. Everyone should have them. It's also important when you're navigating just generally this idea of how you treat your confidential and proprietary information. There are some expectations out there that if you treat your information as though it is protected, you will have additional protections. If you don't, if you just let everyone have access to it, you're really cutting out some avenues that you might otherwise have. The other consideration that I'll just throw in there as a plug for other labor and employment ideas is PII, personal identifying information, is kind of a hot topic right now. Data security laws, whether not just for your clients or your customers, but for your employees, there are expectations that are sort of growing. Maybe this is our fourth installment of multi-jurisdictional considerations, where data privacy is a really hot topic issue, and it's drumming up. Massachusetts, I know, has a pretty serious law in place. California, surprise, surprise, also has some, as well as other states out there. And so it's not just important from you, employer, for your secret sauce, making sure that you remain competitive, but it's also important from your legal obligations. And also, depending on the industry, if you're a federal contractor, if you're dealing with HIPAA requirements, there are additional obligations to keep information secure. You could be walking into some pretty severe penalties if you fail to meet those basic expectations. Anything to add about trade secrets or these other sort of tools, Zach?
No, I think it's important just to be aware that in some jurisdictions and with respect to non-disclosure agreements, you do need to be a little careful in how you draft them, and the length of time that certain categories of information might be protected from disclosure. So, for example, if customer or client information that would otherwise be confidential and protected under this agreement becomes out of date after 3 years, then a court might say, you can't have a non-disclosure agreement that protects this information from disclosure until the end of time. And they might strike parts of that agreement. So that's something you want to be careful of. You might also want to be aware that if information at some points becomes public, not through the employee leaking it, but just because it becomes public either in the natural course of business or the company wants to make it public, you can't include that information under a non-disclosure agreement. So those are, I would say that would be the main consideration that I'd look at for those.
Really good point. Also, there are certain whistleblower protections that really you'll see if you look at one of our agreements that we drafted in the past. There are so many caveats for what employees can still disclose, through protected channels and considerations. But yeah, it's not as easy as saying you just like anything you hear or say or see, you can't talk about it. There are some layered sort of approaches to what's actually permissible. Okay, so hopefully we've only got about 5 minutes. Oh, time really flies when you're talking about.
For another hour.
Yeah, for sure. So we'll touch on a few of these just considerations as you folks have employees in different locations. Let's talk on a couple. Zach, are there any of these on this list that you are particularly passionate about that you'd like to bring to everyone's attention?
Yeah, I think the garden leave provision might be helpful. So one strategy that employers use, especially in New York, to get around strict non-compete laws, is a garden leave provision. And garden leave essentially means that you are paying someone after their official employment ends to sit on the bench for a period of 6 months or a year, usually at their full salary, to keep them from going to work for a competitor. And those agreements, have been upheld as valid in a lot of instances. One of the penalties that can be enforced against the employee if they violate that and try to moonlight for a competitor on the side is losing all of that compensation, among other things. And then Massachusetts is a state that essentially requires garden leave provision when you have a non-compete agreement for an employee. And there's not a whole lot of ways around that. So if you want to institute a non-compete and the employee is either located in Massachusetts or your company is located in Massachusetts, then you need to consider, do we want to pay this person for 6 months or a year, or potentially even longer, up to whatever the statutory limit is, to just not work for us after they leave, whether we part amicably or we terminate them.
That's exactly right. Other, straightforward, fairly straightforward. There are a number of states out there, we talked about this, have salary or wage thresholds for enforceability. Fairly straightforward, right? If you earn below, I forget, I think Virginia is 78 now, 76.
Yeah, somewhere between 75 and 80,000.
This really illustrates my point, is that these things change.
Virginia's, it keeps going up.
They update it on an annual basis. It's always sort of like a, a guess as to when they're going to let out the latest numbers. There's a formula baked in, but it changes pretty quickly. And so you've also got to keep, like, if you've got someone who's staying at the same wage for several years, but Virginia's non-compete wage threshold is increasing, you could start off, they're perfectly fine above that threshold, and then a few years later, next thing you know, they're below it. So there's a lot of moving targets out there. There's also this idea of someone who's paid hourly versus on a salaried basis, if they're exempt, non-exempt. A number of states, I think at least 4 or 5 now, say you cannot have non-competes for your non-exempt workforce. That is also changing pretty quickly. We mentioned that Virginia's just went into effect today. Yay. Congratulations, all you Virginia employers. Make sure that you're not holding your non-exempt folks to the non-compete obligations. Some states also have fairly onerous notice obligations. Washington, D.C. is one such state. Not only do you have to provide a certain period of time of notice, you have to let them read their agreement, have some time with it, get to know it before you require a signature. There's also an additional notice obligation, basically a form letter. We have copies if anyone needs them, that you're supposed to provide to employees. Also important to know that DC, like Virginia, has a wage threshold. It's much higher. I think it's around 115,000 right now. Could be higher. Don't quote me on that. But it's also changing on an annual basis. So just keep all these things in mind. The only other thing I'll say here is that there are some potential penalties depending on the state of employment. Virginia has, for example, a $10,000 penalty for trying to enforce an unenforceable agreement. So keep those in mind as you're evaluating the risk of having agreements in place. Zach's gonna round us out with sort of best practices as you move forward. He's also going to remind us to share the HRCI code at the end of this. Together, we can probably remember that.
No, I think I've got it written down, so we'll get that out. As far as best practices for employers go, we've kind of touched upon this on non-compete, non-solicit, non-disclosure agreements. The biggest point, the biggest takeaway, I think, from this presentation is, you need to realize that there is not a one-size-fits-all for either your employees, your company, or specific issues. So it's important to really look at what you're trying to protect, who you're trying to protect, and what jurisdictions you're in, as well as the other considerations. So there's a lot to kind of go over, and it's non-compete agreements, while they are still on the way out in a lot of jurisdictions, they can be enforced under certain circumstances. But we typically recommend that clients look at non-solicit agreements, either for customers or clients, or to prevent employee poaching, as well as non-disclosure agreements as your first line of defense. Because those are going to be enforceable in a greater number of jurisdictions than non-competes. And with that, we would love to answer questions, but I think given the time constraints, please feel free to reach out to either Sarah or myself. Our contact information is on the screen. And
great. Thanks, everyone, for dealing with our technical difficulties today, but we got there. We appreciate you joining as always. And yeah, don't hesitate to reach out to either of us if you have questions following, the last hour. Appreciate it, guys.